Yes. 23, sir. Yes. Right. Well, item 21. Yes. The state is substantially aggrieved by the order of the London single judge. Your Lordship may kindly check out the state appeal. There are 3 appeals, and 1 appeal is by the state, where the sum and substance of the, that is WA number 3344 of 2024.
It is not 21.
I'm sorry, I'm arguing 22. Sorry, I'm so sorry.
21.
Your Lordship's item 21, my senior is on her leg, she could not appear. So can I please ask for a pass over?
Passover. Yes. Because after all, we are not taking people. Passover may not be feasible, but you take some day of this first week of August.
Sir, it's a very serious matter, sir.
Therefore, on August first week,
10th.
yes.
One thing, sir, one prayer is, I have filed one additional affidavit. That has not perhaps reflected in the record.
Registry to put up additional affidavit.
I have a copy with me, but it is not reflected in the registry.
Well, first, your Lordship will take up the appeal by the state, that is WA 3344 of 2024. All the 3 appeals are against a common judgment passed by the Honorable Single Judge. But the issue is that the state intended to fill up the post of lecturers in all non-government aided educational colleges, non-government aided colleges.
We are not taking this one. It requires deeper consideration.
No. Only. UGC regulation will prevail over the state or not. That your Lordship was last occasion saying that it has been settled by the Supreme Court. I have examined Supreme Court decisions and I have come with those decisions before your Lordship that unequivocally in every judgment the Honorable Supreme Court is saying that unless adopted by the state, it cannot be imposed upon the state. Federal structure, my lord, the state is to man its institution, and the higher education is the entry number 66 of union list. That for that, but there is a distinction in the union list. Your Lordship may kindly have please consider that 66 entry in union list says,
But this requires a deeper consideration.
coordination is there, my lord.
No, that's not the aim. But matter requires deeper consideration.
This particular case, I'm appealing to the respondent in the first case. My learned friend may not be correct in saying that the state has not adopted the UGC resolution. The clear finding of the learned single judge is that the state has adopted by a notification. The Lordship would kindly turn to page 217, the impugned order. The Lordship would kindly see.
Anyway, let me come before some other page. On 23rd? 23rd? Yeah.
Subject
Whichever date you want.
22nd. So here the entire selection process has been started.
That's why we are eager for disposal, my lord. We are there for
We are not there. Not 26th.
Subject to your Lordship's convenience, we don't want to trouble your Lordships, but can it be 13th Monday? It will hardly take 15 minutes of your Lordship's time.
I am not taking any since I'm an outgoing judge. All matters, complex matters.
Fine. I'm sorry.
Last week of July 2026. Yes.
Particular date.
Yeah, in some date. Not in some date.
But it's a small prayer. If IA for intervention may only be considered, that's all, because we have filed every time the matter is not reaching only IA. The issue is we are the candidates we are the petitioners who are having NEET certificates. Now the UGC regulation says PhD and NEET. Now the state government's issue is they are using the UGC regulation partially. They are saying for pay fixation we will be using the regulation, but for qualification, essential qualification, we wouldn't be using that. Well, it's for that reason, since the last 3 years no recruitment has happened, we approached the learned honorable single judge. Single judge, before the single judge instruction was given that till the writ appeal is not disposed of, no appointment can be done. So honorable single judge also instructed us to intervene into this matter. Malets, we are necessary party, Malets, directly getting affected.
Any objection for allowing the intervening application?
I think my learned counsel.
Malets,
Intervention, we are not having any objection.
Alright.
All
The
in.
recruitment is also there, Lordship.
Two applications, not respond. Let's do application three.
Yes, ma'am.
Three applications in IN number, so and so, right now, like this. Supported by separate affidavits or moved seeking their imprisonment on the ground that they are proper and necessary parties in the right of decision of Apex Court in Rajia Begum versus Shahnawaz Begum, and 58 SC Science. First off, the impediment, except elongating the cost title, would not cause any prejudice to any of the parties. First off. Further, their impediment would be doing complete justice, would be facilitative of doing complete adjudication of issues involved once for all. First off, in the above circumstances, the subject applications having been favored, the appellants are directed to array the applicants as respective respondents to these respective appeals. Forthwith.
But in the meantime, because we are eager for disposal, in the meantime, we'll also fixed up for 929. In the meantime, let them not precipitate the contempt.
Contempt you should not precipitate. No, Malets, no contempt has been filed.
If they, no, they have filed a writ petition because the contempt period has over. Now they are proceeding in a
After
writ
that
petition.
only, that date only will mention the writ application.
Learned AGA Mr. Panda subject that
Number 2.
submit and learned advocates appearing for the pleaded parties agree that the writ petitions pending before the learned single judge would not be precipitated till after the disposal of
Yes,
the
sir. Get.
Yes. Next.
Lordship, 1 that case,